The defense wants a Franks hearing. That's a special hearing to determine whether police lied in an affidavit in an effort to get a search warrant. I want to bring in Philip Dubé. He works as court-appointed counsel in Los Angeles County in California, not affiliated with this case at all. Philip, your thoughts, first of all, on the request by the defense in this case to suppress Bryan Kohberger's genetic information. To me, that has always been one of the major things in this case was the use of genetic genealogy. And we knew, because this is being used in an active case and not a cold case, it was more of like a hot case, that the defense was always going to fight back against this genetic genealogy being used to identify him as a suspect.
Well, I got to tell you, it's a pretty novel approach, and I got to give kudos to defense counsel because it's actually brilliant. She's doing whatever she can to protect her client in a death case. Having said that, I'm not sure that her client has standing under the law. In order to challenge any type of search or seizure under the Fourth Amendment to our Constitution, a defendant has to have legal standing. And what does that mean? It means that he has to have a legitimate expectation of privacy in the item or the place that's being searched and seized. And if the data in this particular case is the type of data that was voluntarily submitted to a virtual public database for millions of people to access and look at and download and analyze, then you don't really have an objective, reasonable expectation of privacy. The United States Supreme Court revolutionized this notion of privacy interest back in the 60s in a case called Katz versus United States. And what the court said is, look, the old standard that we used to use in deciding whether or not a search was valid is whether or not you had a possessory interest in the place or the thing that's being searched or seized. And what they did is they changed it to a privacy interest. And I think under these facts, he may have a subjective expectation of privacy in it, but objectively, I think the courts are going to rule against him.
That's very interesting. And we know that in other cases where this has been brought up, the use of genetic genealogy, there is some case law, although I'm not sure there's a lot of case law, but there is some law on the books that allows the use of this. But this is really the linchpin in this case. They had to go that route because the DNA profile left on the knife sheath was not in CODIS. And we don't know the exact arguments they're making, Philip, unfortunately, because the defense's motion, they filed the motion, but then exhibits and things of that nature, a lot of this stuff is filed under seal. But we know that they've been contesting this from the get-go. So you think they're not going to be successful in this?
I absolutely think a judge is going to deny that motion. First of all, the state of Idaho doesn't even provide the right under their state law or under their state constitution. So sometimes if the United States Constitution, through our jurisprudence from the High Court, doesn't provide that right, we can look to our state case law. And I don't believe Idaho is ever so held that you have standing to challenge ancestry type DNA in these databases. It just doesn't exist yet in our jurisprudence. Now, having said that, it doesn't mean that the High Court cannot extend the bounds and the reach of the Fourth Amendment should the matter be taken up on appeal after conviction. And you never know what our High Court will do. But I think if you follow the trajectory and the course, if you will, of most of the cases coming out of this type of data, I do not see this being successful on appeal.
Very interesting. I want to go now to the next thing that they're asking to suppress, the next motion to suppress, and that is really the search, any evidence seized during the search of Bryan Kohberger's parents' home in Pennsylvania, and then any statements that he made. I mean, they make a number of arguments claiming that the police violated his rights by not knocking on the door and allowing him to surrender. I find that to be an interesting argument, given the fact that this is kind of what cops do. I mean, you're going in to arrest somebody for a quadruple homicide. They don't just knock on the door and say, "Yoo-hoo, can we knock, knock, knock? Can we arrest you?" I mean, this is what cops do. They go in with a SWAT team. This is how it works. So they're making a number of arguments saying that his rights were violated and he has a right to challenge this warrant because, even though it's his parents' house. But this whole idea that they didn't knock on the door seems like an interesting argument to me.
Well, first of all, he does have constitutional standing to contest a search or a seizure done in his parents' home, even if he was just an overnight guest. So let's just assume he wasn't living there full time, but he'd come by occasionally or drive across the country to go visit. The courts have held that even overnight guests have standing to challenge a search or seizure. So if he had belongings in there or they wanted to interview him and they actually had a warrant and went in there, they can do it. The question now is, does knock and announce give them suppression, if you will? If they fail to knock, wait a few seconds, and then force entry. And unfortunately for Bryan Kohberger, back in, I think it was 2006, the High Court abrogated suppression as a remedy for a knock and announce violation. Yes, there are safety concerns. You want to knock, you want to announce your presence and let people know why you're there. Knock, 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 FBI, we have a search warrant. You wait a few seconds in the middle of the night for people to get dressed. You never know. They might be walking around in their birthday suit or in their underwear. So you give them a chance to be decent. And then if you don't open the door, they can just raid the place with a battering ram, But let's just pretend hypothetically that they didn't do it. Let's just say they knocked and just bulldozed their way through. And of course, they go and they seize everything. The High Court said that the remedy is not suppression. As discourteous as it might be from a law enforcement standpoint, your remedy is purely civil in nature if you want to sue them for disturbing the peace or for any type of tort that may have occurred under color of law. But constitutionally, that evidence is coming in. The question is why? I'll tell you why. Because they got a warrant. Remember, they're there with a search warrant. It means that a magistrate has reviewed the factual basis for their need to go in, and a judge has approved it and found probable cause. So they showed up there with the document, and the courts are not going to suppress a boatload of evidence merely for a technical violation. They're just not going to do it. Instead, their remedy is purely civil.
They're also wanting to suppress the statements that Bryan Kohberger made during this search of the house as he was transported, when he was at the police barracks. That might be pretty tough as well. I mean, he's a pretty intelligent guy. He's a PhD student. They talked about a possible Miranda violation. We don't know the nitty gritty of that because these items are filed under seal again. But they're looking to suppress, obviously, they're looking to suppress anything and everything. So they're talking about all of the statements that he made.
Well, the first thing the court's going to look to is, was he in custody? If he wasn't even in custody, then Miranda's not even triggered, because the Miranda doctrine, if you will, only applies to people who are being taken to jail and then being questioned by the police. So if he's free to leave, or if he's just, voluntarily being escorted down to the station and he's just doing so of his own free will, then constitutionally, your rights under Miranda are not even triggered. But let's just pretend hypothetically he is in custody. They just haul him in, cuff him, and he's in the squad car on his way downtown. The next part of the inquiry is he being interrogated? Because again, Miranda only applies when you are being questioned by police about the crime, not about ordinary booking procedures like what's your name, what's your height, your date of birth, where were you born, do you have any medical problems? Booking questions and things of that nature are not considered legal interrogation under Miranda law. So from that standpoint, there's really nothing to suppress. But let's say he really is in custody and they are questioning him along the way. You want to tell us about what happened. You want to explain to us why your DNA was on a sheet. You want to explain to us why your car was at the scene, this kind of stuff. Without Mirandizing him, then yes, they have a meritorious motion, and everything he said for not being properly Mirandized will be excluded from evidence. That is the sanction for the violation.
Let's move on now to the electronic evidence. They want to suppress, they're asking to suppress everything, his Amazon account, Google, Apple, AT&T accounts, cell phone records, all of this electronic evidence. They're basically saying these affidavits for the search warrants lacked probable cause, and they only got these because of the genetic genealogy information. So just because you're asking to suppress the information, does it necessarily mean that it's damaging to your client or incriminating? Or do you do this because you see things in there and or you think it was just a grave constitutional violation? Can it be both, or what do you think about that?
Well, first of all, anytime you're moving to suppress evidence, it means that the state has something that they want to use against you at a criminal trial. I mean, very rarely are they on the hunt for exculpatory evidence to exonerate you and set you free. They're looking to make a bust and get a conviction, frankly. Okay, so defense counsel has an obligation. In fact, we're duty bound to sort of enforce the rights of our clients to make sure that they're not improperly interrogated in violation of due process or Miranda, and that they are free from unreasonable searches and seizures. And if they obtained anything, even by way of a search warrant, unlawfully, the remedy is a hearing before the court and suppression. So in a situation where you have a warrant for electronic data or social media data, et cetera, if you feel that the affidavit that was prepared by the law enforcement officer to get the warrant is full of untruths and falsities, or it omits certain facts that would negate the probable cause, then the remedy is what we call a motion to traverse the search warrant. And what that means is the court can go behind the warrant, look at the affidavit, and basically see if the cop lied. You know, if the cop lied, just fabricated things, or deliberately omitted facts that somehow contorted and twisted things into probable cause, then the remedy is suppression. Now, what the court can also do, the court can sever the falsities or the misstatements and the omissions and see if absent the falsities, there's still enough probable cause. So even though you bring what we call a Frank's motion or a motion to traverse, it doesn't mean that everything gets suppressed. It just means the court has to do an analysis to see if the factual basis can be severed and allow everything else in the affidavit to survive and support probable cause. And I've seen it happen over the years. So yes, it's a right in the end without a remedy.
And they are asking for that Frank's hearing. Philip Dubé, thank you so much for your time and your expertise as always.
Take care.
And that's it for this episode of Crime Fix. I'm Angenette Levy. Thanks so much for being with me. I'll see you back here next time.